Hello, Lyric Armstrong here, your real estate agent and advocate. So glad to see you today. Welcome, welcome, welcome. We're going to keep things simple. We're seeing Judge Simpson's court, Cedric Simpson. He um, has a counselor that does not want to continue the hearing. However, there are things that have to be done pre-trial. So we're going to learn about some pre-trial stuff that will help you keep your case moving on track in its timeline versus waiting and delaying things and costing your clients extra money and time, right? Because we never, ever, 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 ever want to overcharge our clients, right? So we don't waste our clients' time by failing to get things done pre-trial, pre-hearing. So let's find out what's going on with these attorneys. Quick conversation, quick look. Judge Simpson's court. Don't forget to like, share, and subscribe. Here we are. We are here. Judge Simpson, we are ready for court. We are here. We are ready.
Court calls the case of Danbury Park versus Sharonda Hill.
Good morning, Your Honor. Mike Zappin on behalf of the plaintiff.
Good morning, Your Honor. Lou Maskill here for defendant.
Okay, where are we on this? I know we had a recertification issue, and where are we?
Your Honor, I've reached out to counsel and I haven't received a response. The ledgers that we have on file, I think I have a lot of concerns about them. So I would like the opportunity to speak with counsel about the case. Maybe we can move it forward. I don't know if I haven't spoken with this attorney if he's covering just for today or not. I'm not sure.
Your Honor, I've covered the last 3 times. This has been adjourned for one reason or another. Their counsel wasn't available. Counsel, they needed records. We're talking a total amount due of $19,810. We are not looking for any adjournment today.
Well, I think there's some significant legal issues at play here, Your Honor. And, we have requested a jury trial. My client has been paying into escrow. I haven't received a response outside of court, Your Honor, for some time. So if you want to set it for
counsel, hold on. Counsel, have you talked with defense counsel about this case and about what their issues may be?
We've provided all the documents to her that she requested. We have not.
I didn't ask that. Have you talked with them about it?
I myself have not. I don't know if Craig Dietz has or if Jeremy has not. I mean, this pretty good tenant not paid anything since December of 21.
Okay, but so how do you expect this case to get resolved if you guys aren't talking to each other at least?
We could I could do a breakout room with her now, but I mean, we're talking.
You guys can answer your phone. I mean,
right?
You come here. I don't want an adjournment. You're stonewalling the other side, not talking to them, and then expect me to just give you a judgment. Not happening here.
She could have called our office if she chose to. It's right on the documents. I mean, what we're talking about.
Okay, you're right. She could certainly do that. And I will tell you, Ms. Maskell has been appearing before this court. I don't think she's ever shy about reaching out about what her issue is. So if you think she hasn't called, fine. Tell you what, you don't want an adjournment? Well, you're going to get it today. Adjourn this matter to the 11th. That's not a date for me. It's a jury date, so I'm going to go the 4th. We'll go August 4th, 2003, 10 a.m. You guys figure out who's going to talk to each other, who's going to answer, who's ever phone call. I don't want you coming back here telling me you haven't talked to each other. Thank you.
Thank you, Your Honor.
All right. Like I said, it was quick, but we learned a great deal. So let's kind of depack what just happened. So plaintiff's counselor is the gentleman. The woman was the defense counselor. And so plaintiff's counselor is in representation of the landlord. And of course, defense is representing the tenant. Love a lot of the assertions that the defense put up. One, that they have been in communication with or at least attempted communication with the counselors of record. They're unfamiliar with this new counselor who came today because he is not the one that is probably the main one on the line, or just not the one that's been working the case along this time. So she's like, well, I don't know if he's only here for this hearing or, what have you, but I haven't heard back from him. And his response is, well, I haven't talked to her, but we've given her everything she's asked for. She may have talked to my colleague. Well, counselor, it's up to you to know. It's up to you to know. So before you go to trial, before you go to hearing, you're supposed to confer with your colleague, and you're supposed to find out from them how many communications have happened with the other side. Where are we? What is the main issue that the other side is expressing? How can we move forward? So either his colleague is not expressing enough details to him, or he's not availing himself of the information, or he's, not requesting it at all. But before you even go to hearing, if you're not the main counselor, or you're not the one who's been talking with the other side, or even if you have a co-counselor, you should definitely have communication with them just to ensure that you know where this case stands before you get into trial. Right? I've said this before a gazillion times because it is true. When you get to court, you should not be surprised. And a part of that means you've gone through discovery, you've talked with everyone, you've talked with your team, the people that are working the case, you understand where the other side is. So when you get to court, you have your weapons in hand to combat whatever arsenal they're going to bring towards you, right? You need to know what your response would be. So counselor makes no sense to not have communicated with his team to find out where they all stand and what the information has been going back and forth in terms of communication. The only thing that can be the case, the other thing that can be the case, either he didn't ask, or he hasn't talked to co-counsel about those particular types of details, or the co-counselor has not responded to defendant's counselor. And that's what her representation is, that she has been making attempts to speak with them about material issues, and they're non-responsive. And she gives an illusion that she's actually calling or trying to reach out to a different listed counselor, because she's like, I don't know, this counselor, if he's going to be on this on a long-term case, on a long-term basis or not, if he's just here for today, I'm not sure. So that gives you some indication that she hasn't really dealt with that particular counselor much, that attorney much, but she has in fact reached out to someone in according to her representation. And the reason why the judge is upset with it is because you're supposed to meet and confer. You're supposed to meet and confer. There are certain motions that require it, but every hearing, you should have had some type of communication, whether you're talking about the 998 settlement communication, or if you're doing a full meet and confer for discovery communication, whatever it is, you're supposed to have a conversation to see if you can have a meeting of the minds. The court is to intervene, but it does not want to have everything on its docket. It does not want to solve every case. So if you can get it off its docket, if you can mediate the matter, if you can settle the matter, which would be like the 998, or if you can at least meet and confer and see if you can settle the matter, these are the steps you do part of pretrial before you go before the judge, so that you can say, we have tried to communicate, Your Honor, and we just do not seem to be able to agree. We have tried on this issue, Your Honor. We have had at least 2 meeting refers, at least 2 conferences, which means conversations. We've had at least, maybe you've had 3 emails. So maybe you'd say, I've had 3 communications with opposing counsel, and opposing counsel just will not budge. And so, Your Honor, we need your help. We need you to make a decision, because the 2 of us have not been able to make the decision on our own. That's why the judge is upset, because you haven't even tried that. So plaintiff's counsel is like, well, if she wants to call, she can call. But at the same time, if you haven't talked to her, and your staff and your co-counsel says they haven't talked to her, it's your job to go and reach out to her and be like, hey, you haven't called me. We should meet and confer before hearing and see if we can get this settled. That's your job. So to not do it is ridiculous. So it's ridiculous. But he wanted to not do it because he does not want to, what do you say? He does not want to be, he doesn't want to continue anymore, because it's been this way since 2021. The end of 2021, and we're in 2023, so that's been 2 years, right? Or almost 2 years, because we're not yet in December, so a year and a half, year plus. And but the other representations that defense counsel gave that I really thought was a good plus for her was that her client is putting the money in escrow. So he made a representation. We haven't received any money. There's no money being received. We have none since December 2021. But the client has been putting the money in escrow. So what that means is it's being held protectedly. It's not as if the client is like, oh, it's in my savings account. No, I'm showing you third party is holding it. They're protecting it from any withdrawals. There's no withdrawals that can happen unless both sides agree to, withdraw. And so, or there's a court order to withdraw. And so, and the point is, I'm putting the money here because we have an issue, landlord tenancy issue that needs to be resolved with the court. Once it's resolved with the court, and however it's resolved with the court will decide how that money gets dispensed. We'll take the judgment, and then you get your money. And so he's like, we have no money, $19,000 in the arrears, and so I really appreciate that she had her client put the money in the escrow account. That's much more professional. If you have it under the mattress, if you have it in the bank account, if you have it in the savings, it can be tempting. If you have the will to not touch it, then you don't touch it. But I really think the escrow account is much better. This is my opinion. No. All commentary and opinion. No advice being had here. But so I really enjoyed that factor that they had it in the escrow account. And I think Judge Simpson did too, because it just shows that they are not being nefarious. They're not trying to, hide the hand or do anything crazy with the money. They are in fact putting it away. So Judge Simpson can solve the case. And so he did not want to have a continuance, and he got one anyway, just because he didn't do pretrial things. And that's really it. Like, if you just have the conversation the day before, it really is, you make a call, you talk, you don't even have to agree. You don't have to agree. You can get on the phone and know you're not going to agree because you've seen the pleadings, right? And a lot of times that's what happens. The attorneys already know that they're not going to agree, so they don't want to make the phone call because they feel like it's a waste of time. No, you gotta make the call. You gotta have a call. So call or email and make an attempt to settle it one last time, have a meeting of the minds one last time, knowing that you won't even in some cases. And then you can go before the court and say, hey, Your Honor, no, actually we talked yesterday. And counselor wants me to dismiss the case, and I don't want to, so we're not in a place where we agree. So we have to come here and have an actual trial. We have to come here and use the services of the court to intervene because we don't agree as counselors, and as our litigants don't agree. So anyway, that was a real quick look, just a little peekaboo look at what pretrial steps can do to you, right? If you fail to take them, if you do not take the proper step of just making a phone call or returning a phone call or an email, something so simple as communication, you can find yourself just going ahead and continuing. Does not mean that he loses the case, it just means he has to wait another day to fight. And I know that he probably will be real ready and he will get on the phone and get into some emails and communicate with Madam so that he can go ahead and have his trial. And oddly enough, they're requesting a jury trial. So they're going to have a jury trial. This will be interesting. I can't wait to see it. And so hopefully you'll be back and we'll see it together. All right, like, share, and subscribe. Let someone see a phone call that's so simple and it can help with your case. All right. Lyric Armstrong, your real estate agent and advocate.